Good afternoon, and thanks for joining the first in our series of webinars looking at inquests and investigations. I'm Tim Cooligan, a partner at Anthony Collins Solicitors and head of our regulatory team. I've been involved in advising a variety of clients in inquest proceedings for over 20 years, in inquests which have lasted from a matter of hours through to 2 to 3 months. The regulatory team at Anthony Collins has significant experience in supporting clients through the inquest process, and our work focuses in particular on the housing, social care, charity and education sectors. I'm very pleased to be joined by Sarah Humbach, who's a senior associate in our personal injury and clinical negligence team, in addition to her experience in representing the interests of families and the deceased during inquest proceedings. She's also an assistant coroner for Derby and Derbyshire. During today's webinar, we'll provide an overview of the inquest process and also look at the potential implications for any organisations involved. That will include looking at the direct outcomes of an individual inquest, the power of the coroner to issue a report when they identify a risk of death occurring in similar circumstances, as well as the risk that a critical outcome may trigger further legal proceedings or regulatory action. In the remaining webinars in the series, we'll look in more detail about conducting internal investigations following a fatality and the importance of thorough preparation for the individuals and organisations concerned. I'll turn to Sarah, who will be outlining the key features of the inquest process.
Thank you, Tim, and welcome everybody. So as Tim has said, not only am I a solicitor with Anthony Collins, but I also sit as a coroner as well. So I'm hoping to take you through a whistle-stop tour of the coronial process, really from the practical side as I see it as a coroner. So first of all, what is an inquest? The most important thing to say is that it's a fact-finding inquisitorial process. It is not adversarial. The role of the coroner is most definitely not to apportion blame or fault. Those are for other types of court proceedings. The coroner must determine 4 questions. Those questions are who died, where they died, when they died, and how did they die? So as you can understand, the first 3 of those questions are generally straightforward. It's the 4th question, how did they die, that really causes the need for the investigation. At the conclusion of an inquest, the coroner must then complete what's known as a record of inquest. That is a public document. It is then submitted to the registrar and it allows the death registration to be completed. So when is an inquest held? I think the first question to ask there is, first of all, is why is the coroner involved in the first place? So a death is reported to a coroner where the medical cause of death is unknown, where it's known from the circumstances that the deceased has died in violent circumstances, where there's a suspicion there may be an unnatural cause of death or that the death has been materially contributed to by an unnatural cause. And fourthly, where the death has occurred in custody, say police custody or in prison, or where the deceased is detained under the Mental Health Act. In practice, the referrals come generally into the coroner's office from general practitioners, paramedics, the police, or the hospital doctor. As I say, they come into the coroner's office and they come into the coroner's officer. That person is a very important person to you. It's that person that you will be dealing with throughout the process. They are the eyes and the ears of the coroner. They're generally very experienced. The referral at that stage will have some very basic outline information of the facts. And so then that information is passed over to the coroner. And at that stage, the coroner must make his or her first decision. That first decision needs to be, well, is this a death that I need to be investigating? So, for example, does it fulfill one of those 4 criteria that I said, cause of death unknown, unnatural? The coroner must then consider, is a post-mortem required? In some circumstances, the referring doctor will have given a medical cause of death. The coroner will look at that medical cause of death We'll also compare it to the facts that have been provided, and in certain circumstances, the two will fit together and a post-mortem will not be required in order to understand how this person has died. But in the majority of cases, that won't be the situation and a post-mortem will be required. Out of interest, it's only a coroner that can order a post-mortem, and where the death has been referred to the coroner, the body is actually the property of the coroner for instructions as to what has got to be done until such time as that post-mortem has been carried out. The post-mortem will be done generally quite quickly, and the reason for that being so that the body can then be released to the family for burial purposes. That does not mean to say that the post-mortem report will be available quickly though, because sometimes further investigation is required, such as histology or toxicology. In those circumstances, body tissue will have been taken, or bloods and urine, and sent off for further testing. Once the post-mortem pathologist's report is available, the pathologist will send through a very initial view as to cause of death. Can't be determined without further investigation, such as histology or toxicology, or the pathologist will be able to say this is the cause of death. And at that stage, that's when the coroner must make a second coronial decision. Sometimes what will happen is that, for example, if the medical cause of death was not known, the pathologist has come back, and for example, it's a cardiac event that has given rise to the cause of death. When compared to the facts, the coroner may then decide, actually, this is a natural death and no further investigation is required, and the matter is closed then. So at that point, an inquest is not opened. In other circumstances, however, the pathologist's cause of death will confirm that no, this is an unnatural death. I do need to send it to an inquest. And so then the inquest is opened and it's adjourned for further investigation. In a lot of cases, it's the police who carry out the investigation. It's the police in those circumstances are effectively an arm of the coroner. They're carrying out those investigations for the coroner. It's not that there's going to be a criminal investigation to follow. They're not doing it in the criminal law arena. They are acting as officers of the coroner. The reason for that is that generally it's known that the police are usually more adept at being able to complete the witness statements, and they compile a file and they'll ultimately send it to the coroner. In some cases, however, from the outset, it's known that criminal charges, criminal investigations do need to be followed through. And it's at that point, once the inquest is opened, that really, in most cases, the role of the coroner comes to an end, that the matter will carry on through the criminal courts, that there will be a charge, there will be a conviction. And in most cases, the evidence will not be aired in court. And the reason for that is because it's considered there's been a full and frank investigation as to the circumstances of the death. And the matter is then just really rubber stamped through the coroner's office to complete the record of inquest and submitted off to the registrar. The investigation stage is important if there's going to be, once the inquest has been opened. It's important that if your staff are going to then be involved, if you're going to be involved, your staff are going to be involved in drafting or preparing statements, it's important that those statements are helpful to the coroner. It's important that what's written down is that it actually tells the story. From my personal perspective, sitting as a coroner, I urge you to try and avoid using acronyms. Please never assume that the coroner knows what you are trying to say. Don't assume that the coroner, in fact, knows how you operate your service. If you feel that you are giving more information to try and explain how the service works, why you did what you did, or your witness did what they did, say it. As I say, the best thing you can do is tell the story, don't assume the coroner knows. If you're dealing with acronyms, explain what those acronyms are. Also, be helpful with the records that you send to the coroner. So, for example, if it's a false case, automatically send the risk assessment, send the care plan. The other thing I'd also say is if your investigations into what has happened has sort of shown that there have been failings, then say so. Say it from the outset, be open about it. Coroners like that, and it can serve to assist with decisions at the end of the case, such as whether or not there should be a prevention of future deaths. And I'm not going to go into that at this stage because I know Tim's going to deal with it at the end of this webinar. In a complex case, or in a case where you're concerned for whatever reason about what has happened, about the coronial process, it may be that you've got concerns because of your own regulatory status, because of insurance, because of the press. It's at this early investigative stage that you may find it beneficial and helpful to take legal advice, to help perhaps with the preparation of a statement, to have a solicitor look over the statement or the disclosure. If that's going to cause a delay because the coroner's officer may have said to you, I want the statements and I want them by this date. And if you want to take that extra step at this stage, just that measure, but it's going to cause a delay, go back to the coroner's officer and explain what you're doing, explain that you aim to deliver the statements, aim to deliver the disclosure by this date. Generally, I would say that you'll be granted an extension. And the reason for that is the coroner would much prefer to have a more detailed bundle sent to them than it all be dealt with in piecemeal. And in fact, actually, some evidence only comes out at the inquest itself. Communication is the key. Communication between yourselves and the coroner's officer in that regard. Article 2 inquests, I'm really not going to spend a lot of time here. In the main, if it's said that it's going to be an Article 2 inquest, that would be most definitely where someone has died in custody or detained under the Mental Health Act. But it's in situations where the coroner may feel that actually this is a systems problem as opposed to it being an individual matter of judgment or an individual matter of failing on that particular day. As I say, I'm not going to spend too much time on that. I'm sure you're aware that there are situations where the coroner will sit with a jury. In the vast majority of cases, it will be the coroner sitting on his or her own. But there are in certain cases, and it's listed there on the screen, where it's mandatory to have a jury. The bottom one says if the senior coroner thinks that there is sufficient reason for doing this. I can't give you any hard and fast rule for that. I could perhaps give you one example that I was involved in actually as a solicitor. It was when we were dealing with the Mid-South Hospital cases, and as you know, that they were all over the press at the time, and a death of a lady in hospital. My clients were the family. The coroner in those circumstances did decide to sit with a jury. I think that was because of the concern there was so much press interest. So those are the circumstances where there would be a jury. So we've opened the inquest, we've adjourned the inquest, and investigations are going on. Part of that investigative process, particularly in a complex case, particularly where, for example, there will be a number of interested parties, the coroner will decide to have a pre-inquest review hearing. I think the best, as the slide says, it's a preliminary directions hearing, or another way to think of it is that it's a case management hearing. The coroner will invite the interested parties to come to this hearing. If an interested party has got legal representation, you can send the solicitor, or if it's a barrister, on their own. There isn't a need for the interested party themselves to attend, because it really is just a case management hearing. There is no evidence given, heard, determined at the pre-inquest review hearing. It will deal with matters such as we see on the screen, the scope of the inquest, perhaps how long the inquest is going to take, whether a jury is needed, the witnesses who need to give evidence. So that's your pre-inquest review hearing. Who will attend? So once we've had the pre-inquest review hearing, at that point, the coroner will, more likely than not, have given a date for the actual inquest. And so who will attend the actual hearing? You've got the coroner, the interested persons, and their representatives if they're going to be represented. In a lot of cases, the family won't have legal representation. The reason for that being is because the cost of it, the cost of instructing a solicitor. Generally, they can't get legal aid for inquests, and in a lot of cases, the family won't be pursuing a civil claim, so there won't be a solicitor instructed. It's in those circumstances the coroner will try and assist the family, really just to make sure that that they've got the opportunity, that they understand the process that is happening before them at the hearing. Obviously, the witnesses will attend, members of the public, because the court is actually a public court. Also, members of the media. In practical terms, what I can say is that the coroner's office, every day, each morning, one of the first things that they do is publish on the website, or will contact the local press to give a list of the inquests that are going to be heard that day, whether they be documentary inquests or whether they be attended hearings. The media will know which ones they want to attend, generally because maybe there has already been a story about the particular circumstance, the particular death or whatever. From matters of practice, media do tend to be interested in attending deaths involving suicide, for example. So, the media are there and obviously they can report. Inquests are recorded, again, whether that's a documentary inquest or whether it's an attended hearing. Those recordings can be made available. They can be made available to the media, and they can be made available to an interested person, generally by contacting the coroner's office, and you can ask for a copy of the recording. So then we come to the hearing itself. So you've heard me mention a documentary inquest or an attended hearing. The coroner, once the investigation has been completed, so the coroner has got all of the witness statements that he or she feels that is needed. Obviously, they'll have the post-mortem report and any other records that are relevant for the purposes of determining the facts surrounding how this person came by their death. If after reviewing all of that evidence, the coroner feels that there's no part of the factual evidence that is controversial, so there isn't sort of two witnesses conflicting with what's being said or what is in the records, that the facts are clear, that the facts also support what is being offered by the pathologist as the medical cause of death, and that there is nothing in the records that lead the coroner to have any concern that there is something has happened here that actually gives rise to a risk of future death, the coroner can then decide, actually, this is suitable for a documentary inquest. What that actually means in practice is that the coroner sits in court on his or her own. Literally, the inquest is being recorded, and the coroner admits into evidence under Rule 23 of the Coroners Act the documents, the statements on which he or she intends to rely in order to come to the findings that the coroner has got to find, such as answering the 4 questions, the identity of the deceased, the place of death, the date of death, and how the deceased came by their death, and then ultimately forming a conclusion as to death. And the coroner does not feel that by having a witness come in and give oral evidence is actually going to add to anything. It's in those circumstances that that can be a documentary inquest. In advance, once that decision is made by the coroner, and in advance of actually holding the documentary inquest, disclosure is given to the interested parties, so the family and anybody else who is made as an interested party, whether that be the care home, the housing association, the NHS trust, is sent a disclosure bundle that this is the evidence on which the coroner intends to rely on, and asks if anybody has got any objections. We always hope that in advance of that, the family have raised their concerns. It may well be that the concerns are known from the outset because, for example, they've already raised them at the time with the care home or with the hospital, or they've spoken to the coroner's officer. And in those circumstances, the coroner would generally get a feel that, no, this won't be able to be a documentary inquest. I'm going to have to call a witness to be able, so that the family can actually see that a full and fair inquiry is being held. But the family, so they see the documentation and they've got the opportunity to agree or object to this going through as a documentary inquest. If everybody is in agreement, the coroner sits, as I say, in the court on his or her own, goes through the evidence, makes the findings of fact, comes to a conclusion, completes the record of inquest, and that is then submitted to the registrar, and that is the end of the process. The press can be sat in court with us if they choose to do so. Indeed, even the family can sit in court, or any other interested person, but nobody would be giving evidence. Nobody would be asking questions in those circumstances. The alternative is an attended inquest. So the coroner has been through the witness statements, has been through the documentation, has got some concerns. Maybe that the coroner's thinking, what I'm being told here, I just don't understand it. I need some more information to be able to clarify certain points, or may have some concern about, if this practice were to carry on, there's going to be a risk of future death. So we'll want to hear more about that. What I will say, as again sitting as a coroner and from experience as well, is that whoever you put forward as a witness, whoever you put forward as the witness to give the witness statement and then to go on to attend the hearing, make sure the person actually has got full knowledge both of the facts, full knowledge of what it is that they are saying. So, for example, I'm using falls again as an example, that don't send somebody who doesn't know why a falls risk assessment is done, doesn't understand the risk of not having a falls assessment. And what your witness should never be doing is trying to guess when they're giving evidence to the coroner, because that really is when that person is going to become unstuck. If it's a manager that is going to be called to give evidence, perhaps because the coroner wants to know a little bit more about really the policies and the procedures that lead to certain decisions being made, that are relevant to what has actually happened in this particular death, make sure that that manager is going to take ownership of this particular issue and isn't going to try and blame it on somebody else, because again, that is something that a coroner just really, you're going to get on the wrong side of the coroner if that were to happen. So again, that may be another touch point where, particularly if it's a case that you are concerned about, and you'll know in advance why and which cases you should be concerned about, that could be another touch point to touch base with solicitors to make a decision if you haven't already made the decision that actually there might be benefit if we were to have legal representation at the inquest. Like I said, a lot of families don't have legal representation. There isn't a need for anybody to have legal representation at all, because the main thing is this is not an adversarial process. It's an inquiry. It's the coroner's inquiry to determine the facts. But as we know, and as Tim will allude to at the end of the presentation, it's the repercussions that can happen after an inquest in view of the coroner's findings, and particularly if the coroner is going to make, for example, a rider of neglect as part of the finding, particularly if the coroner is going to raise a report for the prevention of future death, particularly if the press are involved. Then in those circumstances, you'd be very wise to have legal representation there, just to ensure that the points that you would want to be brought out in front of the coroner are actually brought out. Because again, don't assume that the coroner knows everything. So don't ever assume that the coroner will automatically ask the questions that you would want to be asked, to make sure that the certain points that you would want to get over are going to come out. Because in practice, what happens at the hearing is the coroner asks the witness the questions, and after that, each of the interested parties get an opportunity to ask a witness questions. In some cases, there may not be any questions, because everybody may just feel that the coroner has asked all the questions that are relevant. The witness has dealt with them in such a way that nothing needs to be clarified. And so everybody, representatives, could actually be quiet and silent. And if that were the case, I would suggest that it's because of a good investigative process at the beginning. But you'll, you know, in a complex case, in a case that you may have concerns about, it is your safety net to have some representation there if needs be. The process then of the hearing itself, the coroner hears the evidence. The witnesses will be called. The coroner may actually admit some of the evidence under Rule 23, in other words, that the witnesses won't be needed to actually give evidence, because their particular evidence is, like I say, it's uncontroversial. There's going to be no added benefit to have that witness attend to give evidence. Once the evidence has been heard, after that, the coroner generally will retire. First of all, the interested parties are given an opportunity to address the coroner. The parties cannot address the coroner on any matters of fact. What the parties can address the coroner on are where the party feels it's what the most appropriate conclusion would be, or if the coroner is sitting with a jury, what particular questions should be left for the jury. And then after that, the coroner forms his conclusion, and then the record of inquest is complete. These are just a list of the possible short form conclusions. I'm not going to go through them in any detail, just to say that the chief coroner really does encourage coroners to use a short form conclusion rather than a narrative. And so we have that list there. And so now I think it's over to you, Tim.
Thank you very much, Sarah. Having heard all of the evidence during the course of the inquest, if the coroner believes that action needs to be taken to prevent future deaths, then they also have a duty to make a report to the relevant organisation with power to implement such changes. So the housing provider or the care provider in relation to the case, for example. The power to issue a report comes from Schedule 5 of the Coroners and Justice Act. And as a result, in speaking with lawyers about inquest preparation, you may hear them talking about either Schedule 5 reports, reports to prevent future deaths, or more commonly, the abbreviation PFDs. The intention behind the reports is to improve public health and safety. However, there are a number of important considerations for organisations who are involved in inquests. Where, having considered all of the evidence available from their investigation, the coroner concludes that there's a risk of future deaths, they're obliged to make a report. It's not an option, there's a duty to do so. And unlike the formal outcome of the inquest, the risk that the coroner identifies does not have to be directly related to the death. And as a result, the report may focus on other failings that the coroner has identified. And although the report should not set out a detailed review of the evidence, it should provide a clear and easily understandable description of the failings identified by the coroner and the action that they consider should be taken. An organisation that is made subject to a prevention of future death report must provide a written response to the coroner within 56 days of the report being sent. And the report will be publicly available on the Chief Coroner's website. Coroner should also send a copy of the report and any response to all interested persons. And in some cases, that could include the family who may be considering a civil claim. And they can also send a copy of the report to any other person the coroner believes may find it useful. And importantly, that may well include the police or relevant regulators, such as the CQC, Health and Safety Executive, or the regulator of social housing. And as a result, a report to prevent future deaths can highlight in a very public way concerns about how an organisation's services operate, and that may well be drawn to the regulator's attention. It is important to note that coroners are encouraged to consider whether there is a risk of future deaths based on the evidence available at the time of the inquest, and not simply on the basis of what happened at the time of the death. And as a result, presenting clear evidence that improvements have already been made to address the risks may well convince the coroner that there's no need, in fact, for a PFD to be issued. And interested persons and their legal representatives are also able to make detailed representations to the coroner about whether a report is required or not. In some cases, for example, where the evidence is clear that there was a failing on the part of the organisation concerned, as much, if not more, attention may need to be paid to presenting evidence and submissions to demonstrate the lessons have already been learned. In order to demonstrate the nature of a PFD, we have highlighted a section from a report raising concerns about a care provider. The language that is used within that form to describe the failings, I'll go through some of them: little or no understanding from the management why the issues had occurred, lack of recognition of a serious and deteriorating medical condition, and a lack of robust review by the management team, is perhaps far more critical than the measured language that would usually be adopted even in a narrative conclusion. And in that example, it's certainly something that might cause the CQC to reconsider the need for some form of enforcement action if it had not been taken already. And while reports to prevent future deaths are more common in the care sector, there are many examples of PFDs being issued to housing providers. And with that trend and interest from the regulator likely to increase, and the increased emphasis upon resident safety foreshadowed by the Social Housing White Paper, being able to address the risk of a PFD has perhaps become even more important. I now want to briefly consider the potential consequences of an inquest, particularly in the event of a critical outcome or where a PFD has been issued. While the point could have its own dedicated session, it's important to understand that there are very limited rights to challenge the conclusions reached by an inquest. The principal route to challenge would be by way of judicial review, with a requirement to demonstrate that either the inquest had not followed relevant procedural rules, or that the decisions made were unreasonable or irrational. There are, on occasion, successful challenges, and at that moment I do want to say that Sarah has recently acted in a successful judicial review. They are extremely rare, which hopefully underlines the importance of ensuring proper preparation the first time around. As Sarah has mentioned, the press are entitled to attend any hearing, and in high-profile cases will often report not only the outcome, but also the evidence, which may itself be highly critical of the organisations concerned. And while an inquest cannot directly result in the award of compensation, a negative outcome may often encourage the family of the deceased to consider bringing a civil claim, or to make formal complaints internally or to a relevant ombudsman. And certainly the evidence that they and their lawyers, if they're represented, hear and see during the course of the inquest process can be hugely important in strengthening their case. Conversely, handled well, An inquest may also present an opportunity to work constructively with the family of the deceased, helping them to understand what was done to help and support their loved one. And in many cases, the families of the deceased may well be as motivated in seeking to understand what happened and ensuring lessons are learned. And if those concerns can be addressed carefully during the inquest process, it may be possible to minimise the risk of a claim or a complaint being brought. Finally, I wanted to spend a few minutes to consider the potential for an inquest to increase the risk of a criminal prosecution or other regulatory action. There's one circumstance in which there's an automatic requirement for an inquest outcome to result in reconsideration of criminal proceedings. In the event of a conclusion of unlawful killing under current protocols, the Crown Prosecution Service are obliged to consider again whether there should be a prosecution for a homicide offence, even if they've considered the matter before and concluded that that wasn't required. And in the context of representing organisations, the most likely offence to be considered by the Crown Prosecution Service would be gross negligence manslaughter by an employee or corporate manslaughter. And I'll come back onto that in a few more slides. A recent change in the law has made an outcome of unlawful killing more likely, with the coroner only obliged to conclude that this is established on the balance of probabilities, rather than the position as it was, where they were simply had to be convinced beyond all reasonable doubt. We've yet to see how that's going to play out in practice, but it's certainly an additional point of caution for those who are involved in the inquests. And even where there is no conclusion of unlawful killing, the police and relevant regulators may well be monitoring the inquest proceedings, with any new evidence emerging or a critical outcome, making it more likely that they will take enforcement action. In the context of care providers, the most likely regulatory action will be consideration of whether there's been a breach of Regulation 12 of the Health and Social Care Act regulations, and the fundamental requirement to ensure that care is provided in a safe way. Looking back at the example report to prevent future deaths, it will be easy to see how such findings by a coroner might prompt the CQC to think that a prosecution should be brought. At that point, it's worth keeping in mind that while the CQC have been relatively quiet in terms of criminal prosecutions, with only 2 prosecutions a year in 2018 and 2019, they have dramatically increased their activity in this area, with at least 10 prosecutions reported in the last 3 or 4 months alone. In all sectors, there's also a risk of criminal prosecution by the Health and Safety Executive, particularly bearing in mind that Section 3 of the Health and Safety at Work Act extends the duty of an organisation to ensure the health and safety of anyone who may be affected by their operations, in addition to the specific obligations owed to their employees under Section 2. So that, for example, in the housing sector, the Act imposes a broad and general obligation to ensure the health and safety of residents, as well as members of the public who may be affected by the way a housing provider carries out its operations. I've already mentioned the potential for the Crown Prosecution Service to reconsider whether there should be a prosecution for a homicide offence. That could include a prosecution of an individual where there's evidence to show that there was a breach of a duty of care which caused death and should be regarded as a gross breach. Now, the legal test for that is somewhat circular, indicating that a breach will be regarded as gross where it's so bad that it should be regarded as criminal. A similar offence can also be committed by an organisation where a gross breach in duty of care results in death, and that can be attributed to the way in which the organisation's activities are managed by the senior management. And of course, even if a relevant regulator concludes that there's no need for a prosecution, the sorts of concerns raised by an inquest may well prompt lower levels of regulatory intervention. For example, an inspection by the CQC or imposition of conditions upon registrations. Such findings may also be considered to be highly relevant in the housing sector, either by the newly formed building safety regulator or the regulator of social housing. Again, a particular risk bearing in mind their new proposed proactive powers of inspection relating to the consumer standards and a renewed focus on resident safety. Now that brings me to the end of our initial introduction to the inquest process. And in future sessions, we'll look at the way in which organisations and their employees can prepare for inquests to mitigate against the risk that I've outlined. And at that point, we have perhaps 10 minutes or so for any questions.
Thank you both. So we've got some questions come in already. So Sarah, I think this one's probably best placed for you. You spoke about the list that was provided to the press. Joe has asked, is that list only published on the day? And so do the press not get in sort of details in advance of what inquests will be heard?
Different jurisdictions will do it in different ways, and it depends on how sophisticated a particular jurisdiction's technology is. I know that there are some jurisdictions that perhaps will have it on their website up to maybe 6 months in advance for even members of the public to look at. I know that in the jurisdiction I sit in, that it's a telephone call to the press on the morning, so there isn't any consistency across the country. It very much depends on the individual jurisdiction.
Tim, Andrew has asked, were the increased CQC prosecutions in the last few months related to COVID-19?
No. I'm very, very confident that they're not. On average, it takes the CQC something like 2.5 to 3 years from an incident to bring a prosecution, which is obviously phenomenally slow. But I think we can be very confident based on the time alone that increasing prosecution has got nothing to do with COVID. And although I don't have an encyclopedic knowledge of every single case, I'm sure that none of them have got anything to do with COVID.
So then another question is coming from Joe. Sarah, I think this one probably for you. What is the balance between documentary inquests and actually attended hearings?
Oh, that's a good question. And I'm not really ducking out of it. And but I would say it is probably 50-50. Certainly during the pandemic, there was an absolute push to and basically an offer to offer families a documentary inquest. So there was a lot of reviewing of cases that were listed and really looking closely to see if they could be documentary, because all the inquests that were listed for attended had to be cancelled. So, as I say, the pandemic has looked at it again, but otherwise, I'd say it's 50-50 from my own experience.
Tim, Gurpreet's asked, what is the overlap between the inquest and the Safeguarding Adults Review, and are the documents shared?
They are normally in one direction. So there will normally be a request from the coroner to the Safeguarding Adult Review to share documents that have been obtained during the course of the review process. There was a quite high-profile legal squabble, if I can call it that, in relation to a Safeguarding Adult Review that wanted to withhold documents from a coroner, which broadly was resolved in favour of full disclosure to the coroner, but with the coroner then having an obligation to consider very, very carefully whether that material should be shared with the interested persons. There is clearly a huge overlap factually between what a Safeguarding Adult Review will be doing and what an inquest will be doing. And again, that may just be another reason to talk to lawyers in relation to preparation for both processes, because I suppose our experience in a whole range of sectors is the more times an individual witness or the more times an organisation shares information or provides an account in relation to what happens, just by human nature, the account starts changing. People's memories do change over time. And if you provide 3, 4, 5, 6 different accounts to different organisations, so by the time you're reporting to the CQC, perhaps if you're a charity, to the Charity Commission, to the Safeguarding Adult Review, and then to the coroner, you really need to make sure that the accounts that you're providing are consistent. And certainly if there's a significant change from account your first report to the CQC, which says there's absolutely nothing wrong, we got no, we didn't make any mistakes, and then by the time you're being scrutinised in more detail by the coroner, if by that time you're saying actually we accept we've made some mistakes, then the CQC aren't going to look very kindly at that. So there is a huge overlap and a degree of information sharing between the two.
So we've had two connected questions from Gurpreet and Tara. If I just read them out. So if a coroner wants the care service to be involved, will they contact the care service, or can it proceed without the service knowing? And then Tara's question is, how common is it for an inquest to add interested persons at the last minute? Sarah, did you want to respond to those ones?
Yeah, so if the coroner wants the care service provider to be involved, the coroner will most definitely contact the care service provider. It may be though that it's for a particular sort of factual account, and that it doesn't mean to say that they would be an interested party necessarily. Obviously, the care service provider can make representations if they feel that they want to be an interested party, but it's really only an interested person status would be only if the circumstances of that's led to the individual dying are relevant to your involvement. So if, for example, if as a care service provider you're very peripheral, albeit you might be asked for some information, it would be unlikely that you're going to be invited to be an interested person. Can they be added last minute? The answer to that question is technically yes, but that all comes then back down to that investigative process really at the beginning. It's like a lot of things really. Try and front load whatever it is that you're doing in terms of that investigation. Be informative, be communicative, and you're going to avoid, and anybody then will avoid last minute decisions having to be made. But the answer is technically yes, they can.
I'm smiling at that point, and I'm going to say that I'm sure in Sarah's call, where she's always hugely well prepared, that nobody's added as an interested person at the last minute. I can hear Laura chuckling in the background because we certainly have experience in relation to interested persons being added, never mind at the last minute after an inquest has been started. And in a previous life, I certainly had an experience of being called on day two, at least in 2 or 3 occasions, on day 2 or 3 of an inquest, where a coroner had decided halfway through that individuals certainly needed to be regarded as interested persons, and send them off in the direction of a solicitor who might be able to help them, normally leading to an immediate application for the inquest to be adjourned, and a lot of angst on the part of all concerned. That never happens in Sarah's court.
So we've had another great question from Joe. So Joe said that obviously we mentioned riddle reports in relation to jury inquests. Perhaps Tim, this is one that you could respond to. It says, is it the case that there will be a jury where it was a riddle reported incident or injury and the person died at a later point, perhaps in hospital after surgery?
Effectively, it could cover circumstances where the death was initially reported under to riddle, but it would also apply to cases where there was an initial riddle report simply because of an accident or another incident, and then there is a related death at a later date. I can see Sarah nodding along.
Yeah, so it can be. The point that the coroner will be looking at is, has the accident that gave rise to the riddle report caused or more than minimally contributed to the actual medical cause of death? So the coroner will be looking at, first of all, what is the medical cause of death, and then work backwards, and then actually work that forwards as well. And if there is a more than minimal contribution from the accident, then yes, it will go under the process of what you need to do with an inquest where it involves an accident that was reported under RIDDOR and you would need a jury.
And then just in the final minutes, one final question. How do you think the inquest process has changed during the pandemic? And do you think any of these changes will last after the pandemic and we go back to some element of normal?
So I don't think we did look at things obviously closely for documentary inquests, and that was purely though because inquests were being effectively having to be adjourned. I think we'll come back to that, and I gave the statistic of 50-50, and I think it will carry on like that. I think the change that will last going forward, although there's no judicial point on this, but I would imagine the change that's going to last is witnesses giving evidence virtually. So through the use of Microsoft Teams, for example, I can speak from personal experience here that I always feel and always have felt uncomfortable about doctors and care home staff, really anybody on what I call to be on the front line, being called away to have to come to court. And if it can be done, and I think this pandemic has proved it can be done successfully through the use of the Microsoft Teams, Skype, and the like. And I've certainly done inquests where I've had a doctor give evidence via Microsoft Teams, and it was no different to the doctor actually attending in person to give evidence. So I'd like to see that change stay going forwards. Tim?
I was going to say, I think we've seen a huge variety in approaches taken by coroners around the country. Somewhere almost they've taken the view of just blanketly adjourning everything because they feel they don't, in terms of hearings, because they don't feel that they've got the technological capability to deal with hearings remotely. In other areas, we've had extremely successful, multi-day inquests with multiple legally represented parties, where it's worked fantastically. Generally speaking, the cranial services is not well funded. So I do hope that one thing that the pandemic has done is shone a light in terms of areas where we can be more efficient in terms of the inquest process, and certainly using sort of remote technology, I think, will be a vast improvement. And I would again echo what Sarah says, that where appropriate, it's clearly got to be better to be asking frontline staff to be giving evidence remotely, although there may be tactical choices on the part of the organisation, again, about having somebody there in person to really represent the organisation and make sure that their views in relation to the incident come across effectively.
I think just one point to add, where it's being dealt with remotely, so you've got a witness, one of the things we do say at the start is that room that the witness is giving evidence from is an extension of the courtroom. So all the same rules that are adopted in court, so no recording, anything like that must be going on in the room. Someone can have with them a manager or a representative of support by their side, and I have had that, so that because nobody really wants to be there in isolation on their own at all, which if it was to be dealt with remotely, that individual may feel that way, but it can be done so that they've got some support, but it's for support only. And obviously what can't be going on is a conversation whilst and the witness still takes the oath, even though they're sat in their office or wherever. It is an extension of the courtroom.
I think we have a pictorial representation of the entire regulatory team. Just to make the point, if there are any other questions that you want to raise with us, or you want to make an inquiry in relation to an inquest that you may be involved in, then do drop an email to the regulatory team. We have a very, very snappy email address which can get all of us on, which is regulatoryteam@anthonycollins.com. We hope that you found the initial webinar of interest. We look forward to as many of you as possible rejoining us in a fortnight, when we'll be looking at conducting internal investigations and the overlap in particular with HR and employment processes. I'm going to be joined by Matt Wirt, a partner from our employment team. But once again, from Sarah and me, thank you very much for joining us this afternoon.